Okay. Good afternoon, distinguished panelists and delegates. My name is Tobenna Erojikwe, and it's my pleasure on behalf of the Nigerian Bar Association Institute of Continuing Legal Education to welcome you all to today's session of the civil litigation training. It promises to be a very interesting session, and I'll now invite Mr. Tola Oshobi, Senior Advocate of Nigeria, to introduce the speaker and the topic for the day. Thank you very much. Shola, Tola.
Yeah, thank you very much, Tobenna. The topic for today promises to, I think, is a very interesting, important. It's critical thinking. As we all know, litigation or legal practice, especially litigation, is a very, very intellectual endeavor. And in all aspects of litigation, you need to be able to think critically, you need to be able to think original, you need to be able to think out of the box. And so we have, I think, not just the right person to take us through this, the role of critical thinking in litigation. We have Mr. Osaro Ehobamian, SAN. Osaro was admitted to practice in England and Wales in 1989 and in Nigeria in 1991. He's one of the founding partners of Petstone and Grace LP. He's the managing partner of the firm. He heads the dispute resolution group with emphasis on dispute. He also leads the banking and finance group of the firm. Osaro was nominated. He was conferred with the prestigious rank of Senior Advocate of Nigeria in 2008 in recognition of his diligence, passion, and contribution to the legal profession. He was nominated and appointed as the Vice Chairman of the Convention of Litigation, with an organization with the mission of promoting ethical business practices, transparency, and fair competition in the private and public sector. He's a member of the Lagos State Trust Law Reform Committee and the Mortgage Implementation Committee of the Financial System Strategy. He was also a member of the committee that built the framework to create Gele Port, I hope I pronounced that correctly, in Benin. He served as the chairman of the subcommittee set up to review proposed bills for a regulatory framework to sustain the financial system in Nigeria. He has participated in review of several bills in the financial sector. Following the firm's extensive and dynamic work in respect of getting credit indicator and the signing into law of the Secure Transaction Real Assets Act 2017, he was recognized alongside his team by His Excellency, the Vice President of the Federal Republic of Nigeria, for assistance rendered to the Presidential Business Environment Council in securing Nigeria's elevation by 24 in the World Bank's comparative analysis of the ease of doing business. Osaro was appointed the co-chairman of the National Factory Working Group. His contribution to assist the business environment was also recognized by the Nigerian Legal Awards. He's an active member of the Justice Reform Project. The Justice Reform Project is a coalition of Nigerians across the legal profession, civil society, and the general public, desirous of seeing a justice system that works efficiently, effectively, and equitably. He has participated successfully concluded 3 marathons to demonstrate discipline, tenacity, and focus as attributes necessary to effect change and the administration of justice. He has made several presentations to select audiences in securitization, financial derivatives, and capital markets. He's delivered several papers in this area in Nigeria and internationally. Osaro takes every available opportunity to teach law and legal principles to young talents and is regularly at the Nigerian Law School delivering lectures to students. When he's not engaged in the law, he's either spending time with his family or practicing for the next marathon. Ladies and gentlemen, please welcome Osaro Ehobamian, SAN. Let's look over to you.
Thank you very much indeed. That was an extensive introduction. I'm almost embarrassed. I don't know where you got that from, but I'm sure my colleagues did that. Let me start by thanking the organizers for something that you put together, which is highly commendable. I want to commend Tobena, yourself, and the rest of the team, Nta, for this wonderful opportunity. I consider it an opportunity to invite me to speak to my colleagues, because for me it's also a learning exercise. But it is even more interesting that I am talking on a subject which is not one that is dealt with on a familiar level. When the organizers asked me to speak on civil procedure or advocacy, I responded by saying that I'd rather speak on something that was even more important than just the rules and the rudiments of civil procedure. I wanted to talk about critical thinking, strategy, or problem solving that the lawyer needs to make a success of practice. Now, I naturally left the topic to my colleagues. And so when I saw the topic, even though I didn't tinker with it, I found that it was slightly restrictive, the role of critical thinking in all stages of an action. In other words, there was a tendency to restrict the discussion to advocacy. I will talk about advocacy and I will talk about civil proceedings, but it will be peripheral. I would also talk about transactions or solicitors' work, critical thinking, problem solving, strategy is a necessity in everything we do in life. The difference with the lawyers, however, is that you're paid to think critically, but yet there is no institution that you would have attended that deals exclusively with critical thinking. So the first thing I will do is to ask the question, why are we discussing this topic of critical thinking? What is the importance of critical thinking? What is the importance of strategy? Critical thinking, you can equate it to problems, finding a solution to problems. So every human being actually finds solutions to problems. As I did say earlier on, the difference with lawyers is that you're actually paid to think critically and to find the solution to a problem. I'm going to use some slides so that I can catch your imagination. Just follow me and I will explain what I mean as I go along. Right. I trust you can see my screen now. Tola, do I take it you can see my screen?
Yes, we can. Apologies to Barack Obama. Yes, we can.
All right.
Click on slideshow.
On slideshow, just a moment.
So click on slideshow.
Yes, just a moment. Just a moment.
Okay.
I have another Tola here sorting it out. Let me keep speaking while Tola sorts that out. So, when we attend university, what we are taught is the theory of law. And in teaching the theory of law, that doesn't help you with analytical thinking. The best subject that perhaps is closest to it is jurisprudence. but jurisprudence is the theory of law. In other words, the philosophy behind law. It has nothing to do with critical thinking or analytical thinking. So you study the rudimental principles of contracts, and then you look at the philosophy behind contract documents. You study the rudiments of trust. You study the rudiments of torts. But none of this subject enables you to apply or infuse the sufficient level of critical thinking in analyzing your problem, what you are required to do. So the theory is well understood. The theory of law, the rudiments of law is understood. So you understand that in a contract, there should be an offer, acceptance, consideration, there should be certainty. You understand the principles of nuisance in torts. And then you deal with the jurisprudence of law. When you get out of university, you go to the law school, you learn some practical applications, and then you start practice. At that point, you're like a pundit in football. A gentleman who is sitting analyzing football, he understands the principles, but he's not a good footballer because he hasn't practiced. Now you come into practice and you start trying an error on how do you apply these principles. But you stop educating yourself in the theory of law. And therefore, you are unprepared to apply analysis. The difficulty is even more pronounced because you don't even recognize that there's a school of thought on analytical processes that you need to infuse into resolving the problem. It is said that the problem is often solved when you recognize the fact that it exists. So thought is not given to it. Let me then apply what I'm saying to litigation, and then I apply it to solicitor's work. When you're given an instruction, what ordinarily should happen, the pedestrian approach in terms of analytical analysis, is to write an opinion, to think through the process. In thinking through the process, you're looking at what is the objective. So if it's a litigation brief, you're asking yourself, what is the material that is necessary to achieve my client's objective? You're asking the question, where are the witnesses, and do I have quality witnesses to speak to that material? You are asking the question, what are the legal challenges that I face and how do I circumvent them in reaching an objective? In other words, you're creating a roadmap. Every instruction that comes to a lawyer, he ought to first write an opinion. First, think through the opinion. The thinking is a start process. You conceptualize what you're going to do. Then you write an opinion, whether or not the client is paying for it. That process involves analysis. And then you are able to infuse, or you're able to predict a percentage of success. You're able to predict how long it's going to take. You're able to predict the legal challenges. And hopefully, you already have the tools by which you resolve the problem. And then you take on the instruction. Now, it doesn't really matter whether you are paid for that opinion or not. In the absence of that opinion, you will almost be acting like the way the vulcanizers act on the streets, which is when you take your car down there, one who is not so experienced, even if he's experienced, he will try a method. That method may or may not work. They still use carbohydrates, maybe and water, to try and patch the tire. Now, he hasn't thought that if you use carbohydrate, after a while, there'll be air in between it. So he's lacking in the theory of the application, which is supposed to have applied to your tire. It's the same thing with a lawyer. So at the very pedestrian level, analytical thinking for litigators will require you to write an opinion. Let me give you a typical example before I move on to transactional work. When we started practice, Remy and I, we used to pound the pavements in Broad Street, and we walked into UBA looking for work. And they told us that there was no work. But they then told us there were lots of problems that they had because many of their cases were in court, unattended to. Cases were lying there hours on end. So the first thing we did was to analyze why the cases were there. First of all, many of the lawyers were not paid what they were worth. But more importantly, as we wrote opinions, we then discovered that there was a typical problem, which is many of the borrowers who are defaulted, and of course, you know the way a loan will work, you have two separate contracts. You have the loan facility contract, then you have the collateral document contract, which is normally parasitic on the loan. When there is a default by the borrower, the bank will seek to realize that debt. In realizing that debt, and before the bank does that, the borrower would normally approach the bank and either get an ex parte injunction or an interlocutory injunction. We then began to study the documents that the parties had signed, and we found out that the bank would normally load the document with a number of undertakings, requiring the borrower also to meet certain obligations. Some of it were innocuous, and the borrower will never keep to it. And I'll give you a typical example where you have a simple clause stating that the borrower should not move his energy meter from where it is located. And if he wants to do that, he must seek the permission of the lender, the borrower, the creditor. Invariably, because there was always energy problem, the meters will be moved around and there will be no consent being sought from the bank. So what we started to do was to seek a mandatory injunction compelling the borrower to comply with those clauses. And as we did that, we gained 2 or 3 advantages. 1, we gained the advantage of launching to court first. 2, we prevented the borrower from seeking an ex parte or interlocutory injunction. And 3, and more importantly, the dispute normally will relate to both the contract, the capital, and the interests. It will relate to the capital and the interest. And the borrower will refuse to meet his obligation only on account that there was a disagreement on the interests. So when we launch first, we state that we also in that action require the capital to be paid. In that way, we're able to solve a number of the cases that UBA had. It's a very long time ago. And we became most attractive firm to use. Now, we developed a relationship with a number of the lawyers in the bank. Most of them went on to be company secretaries in remarkable institutions. But by just writing an opinion, introducing that critical analysis, we're able to resolve the problem. Lawyers are paid for that purpose. You would have the tools with you, but the analytical process by which you reach a conclusion is a totally different matter. So let me analyze it like this before I go on to look at the transaction. There's a car, it's filled with petrol, and then you have a gentleman who has a license, a driver's license, but he's only just qualified. And the driver is supposed to take you to your destination. He has all the tools with him, but he cannot get there for 2 reasons. 1, he cannot drive properly, notwithstanding the fact that he has a license. But 2, there's no roadmap to where he's going. He doesn't know where he's going. That's what happens normally when we qualify from law school, when we qualify from bar school. We have all the tools, and unless we introduce a level of critical thinking, strategy, and analysis of facts, analysis of evidence, will simply be that driver who cannot take the car even though he has all the tools with him to his destination. Now, in terms of transaction, it's the same thing, and I'll tell you this. When you are required to draft a contract between 2 parties, it is not the document, the contractual document that's brought a party together. It is the document that reflects what the parties are doing. Therefore, the lawyer will have the tools. He wants to be sure that there's an offer, there's acceptance. He also wants to be sure that consideration passes between the parties. And most importantly, there's certainty in the contract. If any of the criteria is not satisfied, the contract might be unenforceable. Excuse me. But many of the contracts people will enter it. We never go wrong. So there will be no need for the court to interpret it. However, your instructions are to assist to create this document that reflects the intention of the parties. But it doesn't stop at that. What you're required to do is identify the risk and mitigate that risk in the event that things go wrong. As a matter of fact, the documents that you're bringing together, to the extent that it doesn't put the parties together, the most important reason why you're putting the document together is to ensure that where there is a risk or where something goes wrong, if that risk materializes, the parties will have in that document a clause that directs how that risk is to be dealt with. So I always say in the oil and gas sector, especially in the upstream, very rarely will people go into disputes. But when the price of oil is very low, people begin to read between the lines and they make lawyers rich. In reading between the lines, they're asking, what risk? A risk has materialized and I need my counterparty to meet that exposure. This contract, this is how I understand it. Now, if you have a good lawyer, the lawyer would have anticipated the risk and then mitigate that risk. That process requires the lawyer to have a number of things within his possession. It would normally be able to apply what Lord Sumption referred to as the experience, the vicarious experience which solved the problem. The interesting thing about practice, law, is that the answer and the solution to many of the problems you don't find in law, you find in other disciplines. And so your knowledge in those other disciplines will come to bear to find solutions to the problem. As a matter of fact, it is for that reason that those who studied logic, mathematics, philosophy, all those analytical subjects do better in law than those who go straight into law. Now, you must ask yourself the question, so if you don't have that background, does it mean that you can't be analytical? Far from it. There are those who worked behind good lawyers, and in dealing with a simple problem, they watch the approach and they watch the analysis, and then they take it on. It's not therefore surprising that you find that lawyers who work with great lawyers themselves become prominent and remarkable lawyers. So I can give examples: Chief Williams, G.O.K. Ajayi, Shofola, Lardner, and a host of others. Ibrahim, quite a few others. You find out that their juniors become extremely competent lawyers. And that is because without thinking about it, they are imbibing the analytical skills that is required to resolve problems. So the question, just go to my next slide. Problem. So when we talk about analysis, we're simply talking about the best methodology to resolve a problem. We are problem solution finders. That's what we are paid to do. Now, every human being has a methodology to resolve a problem. Every human being has a methodology. The problems will present itself in different ways. It's disjointed. It is not presented in any particular way. And I'll give you a typical example of what I'm talking about. If I touch a kettle that is very hot, my automatical instinct is to get off my hands because it's hot. So inbuilt is a mechanism to avoid that risk. There's another way people solve problems in a very lazy way, which is the problem resolves itself. Sometimes it does, and we attribute spiritual intervention to the solving of that problem. That is not a methodology, but it just happened that that problem has resolved itself. But for the lawyers, you apply synthesis. In other words, you apply a methodology. That synthesis and methodology is not unique to lawyer. Anyone who is adept, anyone who has creativity and imagination can resolve problems. But a lawyer has an additional advantage. He can rely on authorities. In other words, the way in which the problem has been dealt with before. It becomes obvious, therefore, that those who have accumulated a sufficient number of authorities within their possession, in other words, reading local international cases, are more likely to resolve the problem. Because if you read a case that analyzes a factual situation, What it means is that when you're confronted with that case, you will know what to do. What happens today is that people just read the head notes. If you read the head notes, there's no way you can be analytical because you are simply looking at the conclusion. How that conclusion was arrived at, you don't know. Therefore, you cannot apply an identical analytical process to the resolving of the problem that you're confronted with. They have authorities, they have cases, they have precedents, and judges are more likely to accept it because it's coming from a brother judge, or it's coming from an international court, it's coming from somewhere which is superior to your pronouncement. And therefore, if you propose a logic, which anybody can propose, not just lawyers, if you propose a logic, which anyone can propose, and if that logical application resolves the problem, you don't have to be a lawyer. What it means, therefore, is that creativity, imagination are more important in the resolution of disputes than the tools of the authority, because you can have the authority, but you don't know how to use it. So if you use the head notes alone, it means that you are no better than a man who is simply applying logic. And whether or not your logic is superior to the next man's will depend on a number of things which I'll be talking about, including what I refer to as your vicarious experience. Take it back. So I said legal authorities do not necessarily provide a solution. Not only because people may not understand how to use it because you're not identifying what the ratio is, but more importantly, many a time your authority does not deal with the set of facts with which you are presented. So authority must never be accepted uncritically. You must criticize the authority. You must critically analyze the authority to see whether it fits into the solution that you're thinking about. It means that for every case that gets to the Supreme Court, you have to be able to identify the ratio as opposed to just the dictum. That process is lacking in a number of us who are practicing because we don't think through it carefully. And that's why you find that a lot of authorities are cited which has no bearing on the issue. I want to talk about the issue in every case. What I see today is that lawyers will draft an issue, craft an issue, something of the nature of whether or not, having regard to all the evidence before the courts, these courts should grant the relief. With the greatest respect, that cannot be an issue. That is the solution of the issue in that case. You must identify the issue that will ensure that once it is resolved one way or the other, then the reliefs are granted. Any issue that is kept before the judge that can be applicable to any case cannot be an issue in the case. So let me give a typical example of what I'm talking about. If there's a set of facts presented to you and the issue is about easement, so the general principle is that if you're building, you must not interfere with the easement of light. You must not interfere with the easement of air. So if a property is being built by the side, it's obviously going to interrupt with it, and you go to court and you seek an injunction and a perpetual injunction, because the principle is you shouldn't interfere with air and lights. But if there is no building there, somebody's creating some bonfire next to your house, so the air is polluted. You start looking at physics as to the extent to which that pollution, environmental issues, and how that is affecting your enjoyment. It is not the same principles that we talked about before that we apply. We're now going into nuisance. We're now going into the extent of the concentration of the air that is coming through your window. The issues are totally different, but they are related to easement. So a simple issue that I'll ask that is applicable to both of them does not resolve the problem. To simply ask whether or not the court should grant the relief. Whenever I see an issue of that nature, there's been no analytical process that's been applied in resolving that problem. You're no better than the man on the streets who simply ask, I need a relief. But it's come to you for you to apply sophisticated analysis, a strategy, a critical analysis. So you start looking at the distinction between whether it's a house that is built or whether the concentration of the air is such that is affecting him. You're drawing from the same principle, but you set the issues differently. That process of setting the issue, as I talked about, that process of writing the opinion is critical. That analysis is critical to finding a solution. Let me apply the same principle to transactions. So regularly, you're required to draft a simple contract. As I said earlier, that contract is a contract that would have all the elements to ensure that it is enforceable. So if you're required to draft a loan contract, a loan facility, you're looking at offer acceptance, consideration, certainty. I see a lot of loan contracts simply say something like the interest rate, which is the consideration, is fixed or floating interest rates. Now, a fixed or floating interest rate, I don't know what that means, but there's obviously infused into that contract a level of uncertainty because you don't know whether it's fixed or floating. The bank is trying to give itself some flexibility. There are ways in which you can introduce that into the contract. So automatically there's a risk which is not identified. And obviously if there's a dispute, the customer goes to court and says this contract, the consideration is uncertain and therefore is not enforceable. And they will win. Now, it's the lawyer who has created a problem because the risk is one that if he had applied himself properly and thought through it, he would have mitigated that risk by applying a more certain clause to define the consideration, which is interest. Because you're paid for that purpose. So, it is important that in order for you to infuse a level of analysis into every problem, you have to have a number of what I call tools to be able to analyze properly. You must have, firstly, a clear and logical mind. Go back on the slides. You must have a clear and logical mind. You must be able to put your thoughts in a coherent manner, whether in writing or orally. You must have what I call a fund of vicarious experience. There must be constant improvement of your vocabulary. There must be emotional mastery. And there must be constant self-appraisal. I'm going to deal with each of this, but I repeat it because it's very important. There must be a clear and logical mind. How do you acquire a clear and logical mind? I'll talk about that briefly. You must be able to string a coherent thought together, either in writing or orally. Simplify complex facts so that you can communicate and it's comprehensible as to what you're talking about. You must have a fund of vicarious experience, constant improvement of vocabulary. The English language plays a significantly unique position in all common law jurisdictions and those that are modeled on it. That's a tool of the trade. So it's not sufficient to get a credit in English or a distinction, and then you stop improving your vocabulary. And I'll tell you one or two things about that when I get there. There must be emotional mastery. I'll talk about that. And constant self-appraisal. In other words, the summary of what I'm talking about, you must put yourself in a position where you are able to provide solution. You must look at yourself. Have you provided solution as it affects you? Are you in a position to provide a solution to a third party? So a clear and logical mind. What does that mean? Indeed, there are subjects that help you to be analytical. And as I said earlier on, the obvious ones are mathematics, chemistry, physics, sciences. Some art subjects also do. So history allows you to, enables you to analyze philosophy. And that is the reason why you find that a number of great judges, both in Nigeria and in the United Kingdom, have done very well because they have backgrounds in other disciplines. The solution to many of the problems are not found in law. They are found in disciplines other than law. I'll give you a typical example. I do a lot of work upstream. There's crude disputes and crude settlements. My best subject was chemistry, and I like economics, statistics. Now, when a problem is presented to me, I'm looking at the problem and I see a formula. I stick to that formula. Often enough, the solution to that problem is in the formula. It's the same thing if you're dealing with a litigation that involves a company. You first have to be able to read the balance sheet of that company. You have to understand, if you're a doctor, that blood flows within the system. So if you don't understand the balance sheet of that company, it's difficult to understand where the pressures are. So if you have high blood pressure, there are parts of the nerves that are closing up because you're taking salts. It's the same thing with a company. Once you are able to read the balance sheet of the company, you're able to provide solutions. Now, you might then ask yourself the question, but I never did any of these subjects. Then there are other ways you become analytical. First, by recognizing that you need analytical skills as a lawyer. So either you gain it by reading subjects, reading widely to give you that analytical skill. And usually what I tell my colleagues is to read foreign cases, read local cases. The old cases are extremely analytical. I talked about some of the great judges, both here in the United Kingdom. Lord Denning read maths. Lord Bingham, these two judges are arguably the most prominent and remarkable judges in the common law this century. In that company, you have Lord Wilberforce, who read, I think, economics. You had Lord Diplock, who read chemistry. In Nigeria, you had Obaseki, who read agricultural engineering. You had Erikefe, who read chemical engineering. I think Oputa read economics, and a host of others. Now, it is true that you have lawyers who did not read this subject who do very well. Those lawyers tend to be extremely analytical because they pay particular attention to analysis. In other words, the way you scope your facts, the way you dissect the facts to identify what the real problem is, and to find a solution to your client's problem. So, what do you do in practice? How do you ensure that you have this sort of thinking? As I said, either you work with somebody who's extremely analytical, or you just read widely. Scholarly works in logic and literature also helps. The two most greatest intellectual virtues are creativity and imagination. So when you see a case, don't accept what it says. Be critical about it. Ask questions. I was listening to an inspirational speaker. So the mother of invention is not, necessity is not the mother of invention. Necessity is failing to accept a particular principle or thesis. That is the mother of invention. Read everything with a critical mind. The next sort of quality that you require is an ability, as I did say, to string thoughts together in such a way that you can break down complex facts simply in comprehensive forms. I'll give you a typical example of what I'm talking about. I talked about earlier on just basically understanding how facts come to a lawyer's office. The facts are never presented in such a way that you can identify the issue as soon as it comes. The facts are presented in a disjointed way. So I recall a particular matter that we had in our office. Counsel acting for this client, a notable client who was renowned, quite a wealthy client of his. And this client had given out properties of his, but those properties were owned by SPV's companies. Of course, when the time came to interpret the will, those who didn't benefit simply argued that the underlying property did not belong to the testator, that it belonged to the company. That is company law, that's correct. We then analyzed it. It was a bunch of documents, it was a complicated set of facts. Trusts were set up around the world. We then introduced trust into the resolution of that problem. Two things First of all, we dissected it to understand where the problem was. It arose because the concentration was on company law and contracts. So we're able to break it down and communicate to the client that we're going to introduce trust. But in doing that, we needed to let the client know the complexities. Now, in doing this, we reduced the problem in very simple, small bits, taking each one at a time. So we were told that the client paid for it, but he paid for it through a company. So we're able to trace that, and tracing in trust can give you ownership. So we're able to establish that the property beneficially was owned, and therefore we argued that it was the beneficial interest that was being transferred, and we won just by introducing a coherent thought into an otherwise complex, simplifying it both for the client and for the judge. So cases do not present themselves in terms of a particular issue. They're disjointed and they come in set of facts. It is for the lawyer to scope it to be able to provide solutions. Let's go to the next slide. Now, I've talked about vicarious experience. What does that mean? Lord Sumption, I borrowed this from Lord Sumption, and I will use my experience as my foundation in law. When I qualified in practice, I immediately, I didn't immediately come back. I wanted to practice in the United Kingdom, but my father would not have any of it. So he asked me to come back. Stop there. It asked me to come back. And I did. You never really challenge your father's wisdom. And I'm happy because we reached a compromise and said I should attend the law school and then go back to England, but I'm still here. Now, after law school, I went on to run my mother's catering outfits in Lagos Island, and I did that for 4 years. In running that outfit, we had major challenges. We had power challenge, access to capital, and the regulators who will come to extort money for one reason or the other. The greatest challenge was access to capital. I needed to demonstrate that we had land before the bank will give you any money. And I said to myself, if ever I get back to law, I would find a solution to that problem. And I did. It was as a result of that challenge, I worked with the World Bank and the Central Bank, and we came up with the Steamer Act. In other words, the act which deals with accepting collateral other than land. And this will help small businesses, accepting receivables, accepting the barber's kits, accepting the organizer's machine as a collateral. And then we also established the National Collateral Registry, where you register the number of these equipments. What people don't realize is that every equipment has a manufacturer's number if it is not fake, and you can register that. So what we introduced into the system was to enable you to take credits, enable you to access credits without necessarily having land, which was the condition at that time. Now, I was only able to provide a solution because I had this experience. And it happens in all other disciplines in law. You will have some experience which you bring to bear. I talked about just reading a balance sheet, which a lot of lawyers would not read. In litigation, I find out that many a time both lawyers might not be able to recognize the problem because they don't have that experience, that vicarious experience. The solution to many of the problems you won't find in law itself, you will find in other disciplines which you have acquired through your experience in life. Lord Bingham in the United Kingdom, one of the greatest judges, he was able to infuse into his judgment his capacity to observe the world because he demonstrated scholarship in history. He was a historian. That was why his judgment was so pleasant to read, because of what he infused at his background. Denning was also the same thing. Having studied maths, you see the way he writes. He challenged the way we use verbs and adjectives. He brought in something that was different in law, and he provided solutions in many respects. Developing the one language, which is a tool to communicate and to break down complex facts, either before the judge or the clients, if it's a transaction you're dealing with. One of the ironies about law is that the law itself is easy to acquire. Usually what is complex is analyzing facts in areas that you're not familiar with, and therefore you talk about specialization. But when a set of facts comes before you, your ability to analyze those facts, and then you use the tool to provide a solution, is what makes you a great lawyer. So how do you improve your English language regularly? And I'll tell you a simple methodology that I have just found. And it does three things for me. It helps to put me in the right mood to be able to provide solutions. So I asked the question, can you give me 3 verbs, active words, in every alphabet, A to Z, that are powerful and purposeful? So let me give you an example. Letter A, 3 purposeful verbs. Just try it. You find out you go blank. But I'll tell you, if I was in a class, it was a physical class, I'll ask the question. Just like I would have asked the question, how many of us write opinions before we provide solutions? So let's try A, R, affirm, aspire, actualize as 3 positive verbs. Let's try B, blossom, beautiful, bless. Let's try C, champion, courage. And we can continue in that way. Let's try D, because D is very interesting. I'll tell you why. So D, we can think of determined, dutiful. Now, when I tried D, it's very interesting. I did something with my colleague in the office. I told him, give me 3 positive words. Determined, dutiful are 2 positive words. I said, give me 3. He said, can he confess to me the 3 he thought about were negative? Death. I said, no, that's not good. Desperate. So, well, desperate is in between. All the verbs he thought about were negative. Now, what does positive verb do to you? Put you in the right mood to be able to provide solutions. But not only that, you increase your vocabulary. When you get up to P, you're talking about prosperity. You're talking about perseverance. All those things that put you in the mood to be analytical. When I talk about mastery, emotional mastery, which will be the last thing I'll talk about, you see what this does. So automatically improving your language, you increase the vocabulary. At the same time, you hone the tools that are necessary for you to break down particular situations, break down it in a comprehensive manner, and convey it. Words are very powerful, and those are the tools for the lawyer. You cannot be analytical if you don't have the language to put across the points that you're making. Emotional mastery. Let me see what time it is so that I don't take time. Yes. Emotional mastery, I think, is the most important tool that you require for you to be able to not only improve your total well-being, but to provide solutions to problems. What does emotional mastery do? It magnifies, it modifies, and it's magnetic. So when you talk about magnifies, your emotions assist positive or negatively to magnify a situation. You can find the way in which you put your points across in courts. You're trying to persuade. Now, your emotions are so powerful. And therefore, there's been a number of research that's been carried out to show how emotions actually neutralize or magnify the situation. In Ohio University, research was carried out with rats. The rats were infected with cholesterol
So something appears to have gone wrong. Let us say, Kosara, are you still there? Okay.
I think
He's gone off completely.
I can still see him here. I think his connection maybe has problems with the connection. I'm sure he will log in again.
Okay.
I hope.
You're muted.
Right. I'm so sorry about that. I've been moving from one. I'm actually in Abuja. That's why the service provider here is not as strong, even though I'm moving from one to another. So sorry about that. So I was saying that how we control our emotions. Now, the important point about this is you can walk your way into emotions that enable you to be more productive. You can talk your way into emotions that enable you to be more productive and more analytical. So I was talking about when we have divorce cases brought to us, we apply a lot of emotions. So there is no divorce that I have done which has ended acrimoniously. So what we do when most times we are instructed by the estranged wife. What we do is to first analyze the problem and let her know how we're going to approach it. We're not going to let the mudslinging get into public domain. So she's going to give us flexibility to be able to relate with her ex-husband or the separated husband. And if she's not going to allow us to do that, then we don't take up the case. What we try and do, first of all, is to calm her down. And we amplify some of the areas where she's wrong and sit with her because, it takes two to tangle. And then we get to the husband, and we must get to the husband through the lawyer, and then try and suppress those areas that she's done very badly and also amplify those areas where he's wrong. Even though we're going to court, what do we achieve? The first thing we achieve is that we never introduce a mudslinging, especially because both parties have lived apart for more than 2 years. So when I see lawyers do that, I said, there's an absence of analysis. Why do you need to state those issues that will remain in the record forever, particularly because they have children? I can tell you, sometimes this takes me traveling all the way to go and look for the husband. Now, I also tell the wife who comes to me, and I joke with them. I say to her, when I finish resolving your case, you probably fall in love with me. And they start by saying, oh, never. And I said, no. I'm saying it so that it doesn't happen. Normally, there are people there and I'm just joking. So we calm her down so that there is nothing that you're bringing before us that is unusual. But what we will not do is to introduce those mudslinging because it doesn't achieve anything. So we analyze what it is. We know what is the objective. The objective is to get a divorce. The objective is to ensure that the children are well taken care of. The objective is not to score points on who is mudslinging the most, which is what normally happens when the instructions come to you. It is emotional. So you need to apply certain emotion in resolving it. So at a point, we started getting many more divorce cases. I said, no, halt. That is not why I'm in practice. I'm not interested in doing divorces. I'm interested in commercial work. But I see lawyers who are experienced in that area, and I see their pleadings, and I say they've not given enough thought to this because there's an absence of actually articulating what the issue is. Let me end like this. The lawyer must always talk himself into a position where he is in a right setting to provide a solution for his client, either because in the bathroom you are thinking positively. I've had a lot of results of cases. One time I had an intellectual property case and I was thinking, how do I deal with this? I was in the Court of Appeal. And I knew that I had the answer, the tools, but I knew I needed to do something dramatic because that was the end of the legal year and the other party was going to take advantage. This was about 5 days to the day. I called my father. I said, don't worry, I just need you to start matter. And that's exactly what happened. So what we do with all the cases that come, we scope how we consider success before we start. There's an index for every case we attend to. There's an index determining what we'll consider as a success. So we have parameters to judge it. And after the case, we sit down and say, what is the thing we could have done better? We're analyzing it. That is what we are paid for. If you cannot provide that answer, indeed, you are actually being paid for services you're not providing because there are many more people out there who are more analytical and logical. The lawyer, however, has that extra thing that is what he does every day. My final point on this is that for everything you see as a lawyer, you must be able to interpret it with a perception that is superior to just literal appreciation. In other words, for a lawyer, there's a big distinction between eyesight and mind sight. Eyesight is what you see. Mind sight is how you interpret what you see. That singular distinction, in other words, putting yourself in a position where you can provide answers and solutions to problems, where you can analyze better, is the purpose of being a lawyer. What I would recommend as I conclude is that the NBA must invite experts who would help lawyers to understand that this part of their job is so critical and so important that we have to give particular attention to it. Thank you very much. Thank you.
Thank you very much, Leonard Still, for your thought-provoking presentation. I believe it's extremely useful, and I myself I've learned a lot from it. Indeed, it was your idea that this wasn't part of our original curriculum, and the idea was original to you typically, and I couldn't agree more when you mentioned that this should form part of what we do instead of being mechanical in our approach to legal work and just going through the motion. We should be more strategic and result oriented and thinking of how best to add value, how to get the work done in the quickest and most effective manner and get the best value for the client and within the shortest time possible. So I couldn't agree more that this is something that we should have at the back of our minds when not only in litigation, as you rightly pointed out, but in all aspects of providing legal services to our clients, probably more so in when we are doing transactions. At this juncture, I'll hand over to Nta to conduct the question and answer session.
Thank you, Leonard Silk. Unfortunately, we do not have many questions. Most of them are just comments, really. So let me just see if, okay, so Dr. Christopher is asking, let me see, that's the only question. I'm grateful for the thought-provoking presentation. Can you give any pointers in the difference in mindsight and hindsight in mediation?
Yes, indeed. In mediation.
In
Did you
divorce
say?
matters. Yes, in mediation in divorce matters. I guess everyone is captivated by, the divorce thing. So I want
Okay. So, the first thing is that when you are instructed in the divorce matter, you must understand that you can't take that instruction as a commercial, as you would deal with a commercial instruction. That's the first thing. You are actually in a position acting as a counselor. You're a counselor in all matters in a way, because when clients come, you're providing solutions to their problem. That's what you're doing. Whether you're drafting a contract, they're expecting you to do that. Now, but with divorce, the person has come to you heartbroken. And therefore, the objective normally is not simply to get a divorce, is to get at the other party as much as you can. In other words, you want to wound the other party because they put you in this position, whether you're right or wrong. Most of the instructions that come to us in divorce matters are usually first tales of how unappreciative the other party is and how wicked this somebody who you got married to. So that's where you start from. And so the objective when they come is, how can I get at the other party, or how can I get everything from the other party in terms of remuneration? So what we do is to understand that two parties, so the mindset, the interpretation of that is to understand that these two parties were once friends. And whilst we cannot get you back together, oh, by the way, sometimes we actually get the parties back, and that's wonderful because we always try. Whilst we cannot get the parties back together, let's first of all identify the fact that, why are you here? You're here because you don't want to live together. That's fine. You're here because you want some money for your children. You are not here, and this is the interpretation of the problem. You're not here, even though that is the motions that you're affected by. You're not here to see how much you can wound the other party. So it takes the lawyer to counsel you that you're not here for wounding purposes. That has happened. You're now here for me to correct the situation. So what I'm interpreting, even though you come and say you want a divorce, what you've come for is not only a divorce, but let me wound the other party. So what I try and do is interpret that and say, no, I cannot assist you to wound the other party because I wasn't there when this relationship was consummated. But I can assist you to have a separation in the most amicable way so that you achieve an objective that you can live alone and yet have the finances to carry you through that process, have the finances to take your children through school. Let's see how we can do that jointly with the other party, because that is an objective, that's the priority. And so it is actually reflecting what the divorce law says. The children are paramount. The welfare of the children are paramount. But when the witness comes to you, and many lawyers just take instructions, because that's why they put all those wicked things in the processes. They take instructions, that's a literal eyesight mind, without using a mind sight, to damage the other party. And in doing that, the real objective is never attained, which is ensuring that the welfare of the children is paramount. So that's the distinction between mind sight and eyesight.
Okay, most of the comments, most of the comments are, the participants are asking for further reading. What sort of books can be read, further reading on this subject? So
you can read, if you go into the internet, critical thinking, you will find a lot of very good work that has been done on this area. It might not be specifically related to law. And what I always do as well is to see how senior lawyers have dealt with very sensitive cases. So the lawyers who dealt with Michael Jackson's case, Mesura, Squats, they speak all the time of strategies, why they put a particular witness before now, why they focused on a particular area. And then also just studying their lifestyle. I run 42 kilometers. That's a marathon. Now, in running a marathon, you're alone and I don't listen to anything. I just think about the administration of justice. I think about how to resolve my problems. Just understanding the lifestyle of great lawyers in itself helps in critical thinking. As I said, if you haven't experienced a thing yourself, you might not be able to provide a solution. But why don't you get involved with those who have experienced it? Get people around you that can think positively all the time. Every time you're thinking, please think positive. When you think positive, you're in a better position to provide solutions, because all the law you read, the regulations, do not themselves provide solutions to a problem. They are just tools. You need to put yourself in that position where you can actually provide that solution that the client is looking for.
Okay, so Winifred is asking, how did you conclude the case you handled where the testament was challenged on the ground that the property belonged to the company and not the testator?
So what I did was, it was a major case, so we ended up in courts. And for every time I succeeded in an interlocutory application, I would go back and ask if it wasn't time to settle the matter. So we went all the way to the Court of Appeal. I had very strong legal points, but I never pursued the legal arguments to the extent where I never realized that there were people behind the issues. So I wasn't egoistic at all. Even though I had succeeded in the applications, I go back and ask for a settlement. So after one or two proceedings in the Court of Appeal, we're able to sit down and resolve the problem. I mean, one of the things that I would say—
Are you done, sir?
One of the things that I would say as well, and I say this to my colleagues, and a bit arrogant, we never give kickbacks to any company secretary. Because we don't give kickbacks, what it means is that we think very deeply about every case we do. So when you instruct us at Petchton and Grace, it means that we have to think very deeply about solutions to the problem, because it's very easy to instruct a friend, a brother who will share his professional fees. We don't. That means we work around the clock. Now, that's a strategy in itself. Now, that strategy has helped us a lot to come up with solutions to the problem, because we're constantly thinking very deeply. So I say to a lot of people, when you give kickback, it stops you from thinking very deeply about solutions. Because if you fail, the company secretary with whom you're sharing that kickback may not think of getting you out. But what I have realized is that where there's no kickback, I create relationship with company secretary that way supersedes the relationship in that particular company. So I give you a typical example. In UBA, most of the lawyers who developed relationship, we all went up to head their legal department. Iconic companies, MTN, international banks, I won't call names. But again, just refusing to give kickbacks has really helped everyone in Petchton and Grace to think deeply. Thank you, Nta. I'm done. That question.
Okay, so sorry, I thought I lost you there. So most of the questions are mostly comments, that really don't, and most of the questions are, I don't know, maybe because of the example that you used about the divorce case. So there are so many questions on that, and I know that this really wasn't about, it wasn't about talking about divorce. So I guess that actually made people, just start bringing questions about that. So I think we're done with the questions, that are,
I'll tell you, is one of those cases
actually is not on a specific matter. So
Okay, hello?
We lost Nta there.
Okay. There's a question here which I think, I don't know if Nta has asked this particular question. Maybe she has. It says, is there a link between the last point of mastering emotions and emotional intelligence? Are they the same?
Mastering emotions and emotional have a relationship, but they are not the same. When I say mastering your emotions, I'm saying that being in control, and you can be in control by basically what you say every morning. If you call me and I'm in the office and you ask me, and I tell you I'm fantastic, I'm in good spirit, I'm doing very well, because I know that I might be dealing with very complex issues, so I need to put myself in that position. That is mastering my emotion. Emotional intelligence requires you, like what I discussed with divorce. At that point, you've put yourself in a motion where you can actually apply that intelligence in resolving a problem. So there are two things. I was talking about talking yourself, walking yourself into emotional intelligence. So look, one of the greatest iconic photographers in the world at one point was ejaculating blood. And he went to all the hospitals in the world to find out what was wrong. Nobody could find out. But it turned out that because he'd been a genocide photographer, taking photography of blood, he started ejaculating blood. So they just had to go to therapy. So what you see and what you internalize is very important to your well-being. That's what I said about mindset and eyesight. How do you interpret everything that comes before you? So I use divorce, but it's the same thing with companies. I say to my colleagues, if you can't understand a balance sheet, you cannot provide a solution to a company. And this is critical because you might not even understand the problem that is a reason. Now, understanding the balance sheet of the company means that you are first relating to that company's secretary. You are relating to the owner of the company. So there's an emotion because you understand how that company is doing in the stock exchange. You might be able to provide some solutions which they've not even thought about, even though it's a dispute resolution that came before your desk. So you are applying emotional mastery and your emotional intelligence to even expand your instructions with that company.
Okay. Onta, do you want to carry on or are you done?
Yes, I'm done, sir.
Okay, let me just ask, since we have a bit more time before I hand over, there's a question here that would you recommend the reintroduction of logic to legal education? I'm not aware that it had been withdrawn. I thought it was compulsory in 100 or 200 level or something.
Exactly. Most of those questions were questions that I didn't think. Yeah.
Well,
we do logic in school.
The logic is important, but I have to distinguish between the theory of logic and logic applied to practical resolution of a problem. They're two different things. So in the universities, what I've not seen the curriculum, but it's just like jurisprudence. Jurisprudence is the philosophy of law. It is not the best way to acquire analytical skills for the purposes of resolving a problem is actually practice and being in contact with those who have applied such skills. And then how many, look, if I read a case, a local case, recently many of the cases are not as analytical as I would like. The old cases are extremely analytical. So if you're in litigation, there are some cases that you must have read, some locus classicus. When I talk to my colleagues and they say they don't know that case, I wonder. Now, what I now do is to read a foreign case, whether from the UK, India, or Australia, to help me with analysis of complex problems. So you need to, even if you've read logic, if you have a background in those subjects, mathematics, physics, chemistry, it helps a lot. Now, when I went to university at Queen Mary, maths was a precondition, not English, which is very interesting. So whilst I would say that the theory ought to be understood, I gave the example of a car and a driver. The driver understands and reads how to drive. But if you met a pilot and the pilot tells you that I qualified today and I'm going to take you to Australia, he's qualified, you'll be apprehensive because the practical application is limited. But if you are told that even whilst he was learning his theory, he was applying practice. So it's the same thing with law. You must consciously teach yourself beyond the logic in the university or even at bar school. Now, at the bar school in England, you focus on writing opinions. So in my final bar in England, I just wrote just two questions in trust, and they were all factual questions and opinions. So you spent a lot of time interacting with factual situations, specific factual situations. Now, after that, you spent a lot of time in your presentation, breaking down complicated facts. You spent a lot of, that's part of the course at bar school, part of it. But as I told you, I have different tools of continuously putting myself in a position where I can provide. How do I focus? How do I ensure that I'm not distracted? I focus by just thinking about the solution to the problem. And so when there's a distraction, my colleagues and I are going through a process now. When you wake up in the morning, you pick up your phone and you're looking at your WhatsApp. Now, the WhatsApp is full of all types of garbage, which does not help you. Now, remember that in the morning, what you start with is what you end with. If you start with a good music in the morning, all through the days in your subline, and you're thinking about that music. If you also start with an analytical skill, because you've read a wonderful case in the morning. So your first 2-3 hours in the morning are critical to what you do in the rest of the day. So if you're a lawyer and you are paid, you must spend the first 2-3 hours working on something that will help you resolve a problem. And usually it's reading a complex case or analytical case or something that will help you, listening to a motivational lawyer. So if you start with just your phone and you're distracted, sending out messages that don't at all enhance you, there's no way you can be analytical during the day. So teaching logic in the university, just answering your question, teaching logic at bar school is the first step. You need those theoretical analysis. But the patient, what you eat, how you exercise, how you put yourself in a position where you can first resolve your problem before you resolve the problem of a third party. I think just a final point on this. I think the importance of critical analytical thinking strategy is such that I would say to Tobena and yourself, Tola, you've done a fantastic job, that it is something that we need to consider bringing experts to speak to us about, because it is one thing that if people don't even appreciate that it's a school of thought that is necessary to be addressed in order for you to provide solutions. And if you don't, it's a big defect. If you do, you're 50% problem solved. So you just be finding out the good analytical skills that you require. So I think the MBA has to pay more attention on this.
Thank you. I think we're done with questions. Thank you very much, Leonard Silk. I just can't thank you enough for coming up with this topic and for the brilliant delivery. I think the comments we've received says it all. Most people are saying they would like to have this video, and some have said that they would like to have the presentation itself. Many have said they would like to have the presentation itself. I think it has stimulated something in a lot of our colleagues. A lot of people are saying they would like to read books on this. I think what you've said, I mean, I've thought about this on a low level, but I've always thought that the educational system in Nigeria generally, not just legal education, doesn't do enough in terms of critical thinking, in terms of educating. We don't teach our people to, I'm sorry to say, for the most part, we don't teach students in Nigeria. And I'm talking from primary school to secondary school to, I mean, not just at the university level. We teach more to remember rather than to think. We don't have any models. We don't have any, even in primary school. I remember in those days where you are writing common entrance, that's what you call quantitative aptitude. But that only comes up when you are doing the common entrance. There is no course in primary schools, and I don't know if that teaches you quantitative aptitude is actually critical thinking. It teaches you logic, try to analyze certain scenarios and study patterns and understand. But no one teaches you. It's only when you're applying for common entrance that you pick the past questions and you try to figure it out. There isn't, and then you look at the GMAT, for instance, in America, their exams that they do, the SAT or the LSAT or the GMAT or the GRE. There's actually a very large critical thinking content in their curriculum. But somehow, I don't know, maybe because we were connected to the British, to follow the British system of education, because I think it has to be ingrained in us from even primary school to secondary school to university. It has to become a lifestyle. It has to be part of our DNA, so to speak. It's difficult to it's important at any stage in your life or career to imbibe critical thinking. But I think the people who design the curriculum in our schools, right from primary and secondary school, should find a way to inculcate it, to introduce it into the system, so that it becomes even part of the mindset of the average Nigerian. I mean, applying critical thinking in every area of life, in every area of work, in every space. There's a saying that what actually created the Western civilization. I'm sorry for speaking for too long, Tobena. What created the Western civilization is doing simple tasks in extraordinary ways, the scientific method and all that. So I think it's so important that it's not just enough to try to learn it as a lawyer. I mean, I think it's relevant in every profession, it's relevant in every space, and it's relevant at every stage of education, and it has to be continuous. So, and that's how you make it a culture for everyone. So thank you very, very much for bringing, for actually stimulating this.
Let me just, I saw a question there, but before I answer the question, it was, do you suggest that collaborative law, in other words, partnership, specialization, which is which now characterizes the two branches of the profession, if that is a way forward? That's one question that was asked. What Tola was talking about, whilst I agree with you that maybe we can improve logic and analytical thinking, critical thinking in the schools, because the lawyer is paid to think critically, in other words, it's equivalent to solution providers, the lawyer, there's a further obligation. So maybe what needs to be done is an awareness that you need this for you to be able to provide solutions to your client. That's what you're paid for. The tools, the learning of this, the rules, the authorities are only a tool by which you achieve the objective. And that's why a lot of lawyers are not in a position to provide a solution. So I would say that there is a bigger responsibility, especially in lawyers, to actually take it upon ourselves to improve. So I won't over-criticize the educational institutions. What I will do is make recommendations that this is good, but we, as lawyers ourselves, knowing that we're being paid to provide a service which is dependent on critical thinking, we need to do that ourselves. Now, on the question that I read myself on whether or not collaborative law is the way forward, I take that to be partnership and specialization, which is characterized in both branches of the profession now, both in litigation and commercial work. I think the answer is obvious. I do some work in banking and crude disputes upstream. I can't cope. I can't even say confidently that I'm doing enough in oil spills downstream. The amount of hours it takes, just human hours. So when I see a sole practitioner says he's an expert in energy law, he's an expert in banking, he's an expert in employment law, it's a joke. I am doing oil and gas. I can't even cover it. So we have colleagues who are specializing in gas. I do a lot of upstream. If there's a downstream issue, I might invite Mr. Kuti to come and, take charge, because it's just so much. Maybe every time it has a foreign element, they drill down. So a one-man practice would have to focus on a particular area and then contribute to it. And let me say this. Every lawyer must ask, why am I in law? What am I doing with law? And where am I taking it to? The question as to why we're doing law, the reason for which we're doing it, and reviewing that question is so relevant. And then it helps you consider the fact that I take it that every lawyer worth success to his name must be able to tell you what is wrong with the law, must be able to predict change and participate in that change. Now, because we don't have that, you find out that our laws are arcane because we're not doing any analysis of ourselves, analysis of where we are in law. So there's a bigger problem with us practitioners than even the educational institution. There has to be this issue of analysis. That's why you find out that we're not really sure what we're doing. We go to court regularly, there's no answer. 5 years, we're just going on. That's because there's no collective analytical thinking about what we should be doing.
Thank you very much, Leonard Silk. I hand over to the chairman of the NBA-ICLE. So Ben, over to you.
Thank you very much, Tola. Before making my closing remarks, I know there are some of the panelists who've joined in today, and I'd like to invite the panelists for their comments. We're quite excited to see that most of you have participated through the sessions. May I first invite Mr. John Baeshia for his comments?
It's a session that is very interesting and very fascinating and very eloquently delivered by our august speaker. I think he himself is a material on the subject. So if people are looking for materials, they should cite him. And I think it will appear that the first time I knew him was when I was at LPPC, when he came there. And you see, when those of us who have had the privilege and opportunity of serving on LPPC see the products that that God himself appointed to go out like this, we're happy because they are representing us well. So I commend him for a job well done.
Mr. Mubiade, I think you need to mute. There's noise in your background.
So thank you very much, Mr. John Baeshia, Senior Advocate of Nigeria, for your comments. May I now invite Mrs. Maya Essien, Senior Advocate of Nigeria, for her comments. Madam.
Yes, good afternoon, everyone. Mr. Osaro, my brother, well done, excellent presentation. I think critical thinking is a very important component of the practice of law, and well done. That's all I'll say. Thank you.
Thank you very much, Ma. May I now invite Mr. Wole Agumbiade, Senior Advocate of Nigeria, for his comments. I think he's just dropped off. Okay. Kelechi Nwaiwu, please let us have your comments.
Thank you for being so much that
We've struggled with that, but thank you nevertheless. I'm sure your comments are complimentary, so thank you nevertheless. So just to, are you there, Kelechi? Just to close, first of all, let me thank, because this is our very last session of this series. And what a wonderful way to finish it. What a brilliant topic also to close on. I must thank Mr. Osaro Ehubame for suggesting this topic. The delivery, of course, was brilliant and stimulating. I mean, it was so stimulating that it triggered off a lot of comments from Tola, you know. And again, I read a lot of the commentary from participants, and some were humorous and hilarious. One, I think a lady said she'd already fallen in love with you. So that made me laugh. But I mean, again, I think it's the appropriate moment to actually mention that there is a lot that our profession has to offer. And in mentioning this, I want to thank especially all the panelists for the time, for the resources, for participating, for contributing, despite the very busy schedule that I know that all the panelists have. It is that desire to grow our profession and to give back that I find very inspiring and stimulating, that when people are approached to help, to be part of growth and positivity, the answer is always yes. And the people actually give their best to it. So I thank all the facilitators who have presented papers, Mr. A.B. Mahmood, Senior Advocate of Nigeria, Dr. Onyechi Azu, Senior Advocate of Nigeria, Mr. John Baesha, Senior Advocate of Nigeria, Mrs. Maya Essien, Senior Advocate of Nigeria, Mr. Osaro Ehobaman, Senior Advocate of Nigeria, Mr. Ken Mozie, Senior Advocate of Nigeria, Mr. Y.C. Mikel, Senior Advocate of Nigeria, Mr. Emeka Nienugu, Senior Advocate of Nigeria, Mrs. Abimbola Akeredolu, Senior Advocate of Nigeria, Mr. Elisha Yakubu Kura, Senior Advocate of Nigeria, Mr. Wale Agumbiade, Senior Advocate of Nigeria, Mr. Abdullahi Yahya, Senior Advocate of Nigeria, Mr. Kelechi Nwaiwu, Senior Advocate of Nigeria. I mean, interestingly, since March, I think this is the 5th or so training that we've had. We've had one in IP media and tech, had another in energy law and policy. We've had it on taxation. We had a mentoring session with Chief Anthony Dibe, which was very well received. And now this 8-day session is brilliant and has been also very well received. So I thank you all for your time. I thank you all for the dedication. And I hope that when we call again, because we'll be doing so shortly, perhaps not on litigation. I mean, Mr. Hilberman's recommendation is very well taken. I think our standpoint is that we don't have a monopoly of knowledge. It's all work in progress, but continuing professional development and emphasis on professional development is essential to the, practice and prosperity of lawyers. And I think we just need to keep advancing this for our collective benefit. So brilliant way to end. Thank you very much, Mr. Ehoberman, for a brilliant delivery today.
I just was going to say that I'm running the marathon and I'm running for a course in the administration to reform the administration of justice. I'm running 42 kilometers. I'm 54 now. I'm going to be running on the 2nd of October in Abuja. And I'm inviting all the MBA members, all my colleagues, to join to run. If you can't run, then you support me by money. We're trying to build a secretariat. And if you can't do that, just support the fact that this is a metaphoric representation of perseverance, overcoming all our challenges, especially in the administration of justice. We must do, a colleague from the UK said to me, do people appreciate such things in Nigeria? I said, yes, I've had companies donate to it. So we can do the same thing they do anywhere else in the world. We have the same competences, but we just need to apply ourselves. So I invite you to join me, Tobena. You have to run. Thank you. And it's good for your health.
I not the last one, but it's okay. I'll be there. Thank you very much.
Thank you.
Thank you. So just to close now, I thank everybody and the participants. You've been wonderful. We've had 2,000 plus delegates throughout the session every day, and that's remarkable. We've had 7,000 plus people registered for this training, 8-day training session. That's brilliant. I'll just say that those who have participated should also encourage members from different branches across Nigeria and actually tell people how educative and illuminating it's been, if indeed you found it to be so. So thank you very much for participating, and God bless you all. I mean, we'll see you sooner than later. Bye-bye. I forgot to say a huge thank you to you, the interim dean of the faculty. Thank you, my brother. Thank you.
Okay then.